Okay, let's dig into this. We've got quite a stack of legal documents here. They detail a really intense multi-year fight between two major personal injury law firms right here in New York.
That's right. It's a complex story. We're talking about Ginarte Gallardo Gonzalez Winograd, LLP, let's call them the Ginarte Firm for simplicity, versus William Schwitzer and his associates.
And our mission today, for you listening, is to cut through all the legal jargon, the procedural stuff, and get to the heart of two key things. First, these pretty extraordinary initial claims about client poaching.
Yeah, sensational stuff, really.
And second, how did the money actually shake out years later in one specific, very large settled case? We want to focus particularly on how the injured person fared compared to, well, everyone else involved.
And what's really interesting is how the documents connect the dots. We see the background, this fierce rivalry, and then, bam, years later, the financial consequences laid bare because of a dispute over that settlement.
Okay, so here's where it gets really interesting, right? The whole thing properly kicks off in 2018. Joseph Ginarte from the Ginarte Firm, and that includes the Winograd name too, Ginarte Gallardo Gonzalez and Winograd, LLP files this massive $10 million lawsuit against William Schwitzer. What was the central claim? I mean, $10 million is serious.
Oh, absolutely. And the core allegation, according to the lawsuit itself, was frankly pretty wild. They claimed Schwitzer was using a, and I quote, briefcase full of cash to essentially steal clients.
Wow. Okay, so not just like aggressive advertising or ambulance chasing in the usual sense.
No, this was alleged to be much more direct, specifically targeting clients already represented by the Ginarte Firm.
Almost sounds like corporate espionage, but for law firms.
You could see it that way. The lawsuit pinpointed a specific connection, a common link, they called it. These were clients Ginarte had referred to a particular pain management specialist. The documents just call him Dr. X. And the allegation was that Schwitzer's people, his minions, as the suit colorfully put it, were going to this doctor's office environment and directly offering these clients cash, like $2,000 or $3,000 in cash, to jump ship.
To switch lawyers right then and there.
Exactly. And apparently they'd even throw in a free Uber ride to Schwitzer's Midtown office to, seal the deal, sign the new account.
Wait, the service package. A very personalized approach to client acquisition, if true. Highly effective? Perhaps, but ethically questionable.
Well, it certainly speaks to the stakes involved, the alleged lengths firms might go to for valuable cases, but we absolutely have to mention Schwitzer's response.
Yeah, the defense. What did they say?
Immediately, publicly, they called the allegations baseless without merit. Pure professional jealousy, they claimed. And they didn't just deny it, they promised a counterclaim to expose, quote, the lies. So a total clash of narratives from the get-go.
And we do see some fallout from that initial blast. There's an affidavit later in 2019 from a Mignolia Pena.
Yes, that's in the file. She specifically denies meeting Schwitzer or his associates, denies being employed by them, and flatly denies ever offering money or free financing to any Ginarte clients to get them to switch.
So people named in connection trying to distance themselves. It shows how quickly things can get messy when accusations like that fly.
Definitely. It highlights the immediate need to manage the fallout from such volatile claims about improper solicitation.
Okay, let's move forward in time a bit. That original $10 million lawsuit, the one filed by the Ginarte Firm, Ginarte Gallardo Gonzalez Winograd, LLP, just to be clear on the full name again, it eventually gets resolved. There's a settlement agreement and general release signed January 17th, 2023.
Correct. That seems to put the initial fight to bed. They filed a stipulation of discontinuance with the court shortly after, Jan 26, 2023. But, and this is critical, it wasn't a totally clean break.
How so?
The court explicitly retained jurisdiction specifically for enforcement purposes. They essentially built a trigger into the settlement itself.
So it wasn't just case closed, let's move on. It was more like case paused if you stick to the deal.
Precisely. The agreement allowed the case, the original client poaching lawsuit, to be revived and reopened if certain payment defaults happened. And crucially, the defendants, Schwitzer, Rene Garcia, others involved, they waived their rights to argue later that too much time had passed or that Ginarte had waited too long.
They waived statute of limitations and laches defenses. That's ironclad. It means if someone defaulted, the old fight could come roaring back immediately.
Exactly. It was a powerful enforcement mechanism.
Which leads us directly to August 2025. Because apparently that trigger got pulled.
It did. Counsel for the Ginarte Firm wrote to the court. They requested the action be revived, claiming Schwitzer and Garcia had defaulted. They hadn't paid the full amount owed from the resolution of one specific separate injury case, the Sanchez-Fuentes case.
Ah, okay. So the old fight over alleged client stealing comes back because of a money dispute related to a different case settled later.
That's the link. This is where we get into the numbers, the cold, hard cash that caused this whole thing to blow up again.
Let's dive into that Sanchez-Fuentes case. What was the total settlement amount?
The total recovery secured for the client in that case was $3,750,000.
$3.75 million. That's a significant recovery.
A very significant amount. Now, according to that 2023 settlement agreement between the firms, the one that settled the poaching lawsuit, they had predefined how the legal fee from such cases would be calculated and split.
Okay, how did that work?
The agreement defined the legal fee as 1/3, 13, of the total recovery. So 1/3 of $3.75 million is $1,250,000. That's the defined pot for attorney fees.
Makes sense. Standard contingency fee percentage, and how is that supposed to be split?
The settlement agreement stipulated that the Ginarte firm was entitled to exactly 50% of that defined legal fee.
So half of $1.25 million.
Yeah.
That's $625,000. That's what Ginarte expected from this Sanchez-Fuentes case resolution.
That's precisely their entitlement, according to the agreement. But the documents show the amount they actually received was only $475,000.
Leaving a shortfall of $150,000.
Correct. $150,000 short.
Hold on. So the Schwitzer firm allegedly risked reigniting that whole $10 million briefcase full of cash lawsuit with all the bad press and legal costs that entails over a $150,000 payment dispute. That seems like a huge gamble for a relatively small amount in the grand scheme of things. Why? What was their justification?
That really is the million-dollar question, isn't it? Or perhaps the $150,000 question here. According to the Ginarte firm's counsel, the issue stemmed from the closing statement filed by the Schwitzer firm for the Sanchez-Fuentes case.
The official paperwork detailing the payout.
Exactly. Ginarte claims that statement reported only $950,000 in total attorney's fees, not the $1,250,000 that the 1/3 calculation required.
So by reporting a smaller fee pool,
they calculated Ginarte's 50% share based on that smaller $950,000 number, which comes out to the $475,000 they paid. The core of the dispute is why that fee pool was apparently reduced by $300,000 in the reporting. Where did that money go?
this takes us right to the heart of it, the breakdown of the full $3.75 million. If a $150K shortfall was enough to potentially restart a massive legal war, we need to understand the entire distribution picture. This is the really crucial part for you, the listener. How was that money divided up?
And this distribution, honestly, it's the most, staggering part of the entire narrative. It completely reframes how you might think about a total recovery in these complex personal injury cases today.
Okay, lay it out for us. From the $3.75 million total, who got what?
All right. The claimant, Santos S. Sanchez-Fuentes, the actual injured person whose case this was, whose suffering generated the entire recovery, received $500,000.
$500,000. Okay, what about the lawyers?
The reported total attorney's fee, the one causing the dispute, was $950,000. Remember, Ginarte argued it should have been $1.25 million based on the agreement.
Right. So $500 for the client, roughly $1 million for the lawyers involved. That leaves a lot unaccounted for from the $3.75 million. Where did the rest go?
This is the kicker. The single largest share, by a huge margin, went to a legal funder, identified in the documents as Case Cash. They received, wait for it, $1,782,934.86.
Hold on. Let me process that. The client got $500,000. The lawyers got, let's say, around $1 million combined. And the funder, outside finance company, got nearly $1.8 million.
That's what the figures in the documents show, yes. Over $1.78 million.
So the legal funder made more than 3 times what the injured claimant received from the claimant's own settlement.
Precisely. And suddenly you might see why there was pressure or incentive, perhaps, for the Schwitzer firm to try and minimize other payouts, like the one owed to Ginarte, if they had such a massive obligation to the funder.
That massive payout to Case Cash puts the $150,000 dispute in a whole new light. But Ginarte argued the settlement agreement protected them from exactly this kind of thing, right?
Yes, absolutely. This brings us to some very specific and very important contract language they highlighted in their demand letter. It's a clause about so-called dilutive payments.
Dilutive payments, what does that mean?
Basically, Section 2 of their settlement agreement acted like a shield for Ginarte's fee calculation. It explicitly said that the defined legal fee, that $1.25 million number, could not be reduced by certain other payouts.
Such as?
The clause listed things like fees owed to other lawyers, referring attorneys, co-counsel, and crucially, it included a catch-all for other fees or expenses.
So Ginarte's argument was that the massive payment to Case Cash counted as one of these other fees or expenses, and under the agreement, Schwitzer couldn't use that payment to reduce the pot from which Ginarte's $625,000 share was calculated.
That's exactly the mechanism they invoked. The clause essentially guaranteed that Ginarte's 50% was based on the full one-third recovery, $1.25m, regardless of what other large sums, like the staggering payout to the funder, had to be paid out from the settlement.
Wow. And there was more, right? Didn't Schwitzer personally guarantee this?
Yes. The documents state William Schwitzer personally guaranteed the payment of any shortfall arising from this calculation. So that $150,000 wasn't just a firm liability. It became a direct personal obligation for him, according to Ginarte's claim.
Which explains the hard line. The Ginarte firm demanded that a $150,000 shortfall be paid within 7 days of their August 1st, 2025 letter.
A very tight deadline.
And the fact that we have a follow-up letter dated August 26, 2025, stating no response or payment had been received, well, that tells us why they were heading back to court to revive the whole 2018 poaching lawsuit. The default trigger was pulled.
Exactly. It all connects back.
Just as a final piece here, there's another document floating around from July 2025, an affidavit from a different plaintiff, Wilmer Oswaldo Uguna Collaguazo. What's that about?
Right. That seems to be a completely separate case interaction. This plaintiff is essentially authorizing William Schwitzer and Associates to close out his case entirely, related to a different accident date. He waives all rights to claims and agrees to hold harmless the firm.
So it just shows that while this high-stakes battle between the firms is reigniting over the Sanchez-Fuentes case, the day-to-day business of settling other client cases continues in the background.
Precisely. It provides context that these firm-level disputes are happening amidst the ongoing churn of regular case closures and client releases.
Okay, well, let's try to tie this all together if we zoom out.
Yeah.
What a journey.
It really is. What started back in 2018 with these sensational allegations, briefcases of cash, client stealing leads eventually to a settlement. But the enforcement of that settlement years later cracks open the financials of a single unrelated case.
And reveals this incredibly complex financial structure.
Yeah, wherein a $3.75 million recovery intended for an injured person, the single largest slice, over $1.78 million, went not to the claimant, not even primarily to the lawyers who fought the case, but to a third-party legal funder, Case Cash.
So what's the big takeaway here for someone listening? I mean, what does this tell us?
Well, I think it starkly illustrates the sheer financial power that legal funding companies can now wield within major personal injury settlements. Their piece of the pie can potentially dwarf what the person who actually suffered the injury receives.
It really makes you reconsider what total recovery even means, doesn't it?
Yeah.
If the net amount reaching the injured party is so much less than the headline number after funders and layered legal fees are paid out.
Exactly. The biggest winner, financially speaking, in this specific injury claim appears to have been an external financial entity, receiving, as you said, more than 3 times what the claimant themselves got.
Which leaves us with a pretty provocative final thought for you to consider.
When you have these complex settlement agreements, with clauses about dilutive payments governing how legal fees are split between warring firms, and you have massive payouts to third-party funders, how often does the structure itself inherently place the injured person, the claimant, at the very bottom of the payout list?
Is the system designed, sometimes unintentionally perhaps, to prioritize other financial interests over the compensation for the actual injury? Something to definitely mull over.